Good afternoon, folks. My name is Sam Estreicher. I teach labor and employment law, discrimination law, other subjects as well at the law school, and we run a Center for Labor and Employment Law. And we're very pleased to have this program because it's a new area of practice in sports law and in employment law. And it's been put together by folks from the Pryor Cashman firm. Ron Sheckman's a longstanding friend, and he's a member of the advisory board of the Center for Labor and Employment Law at NYU. Nick Saddy is a former student of mine and also co-author, and I'm glad that he has found a home at Pryor Cashman, so we don't have to count him among the homeless at this point. Nick is a very talented person. We are co-sponsored with a number of organizations, and they will introduce themselves. Eric Fishman is in charge of this area of practice at Pryor Cashman, and this is a very interesting field that he is developing. I hope we don't get our college athletes in trouble with the NCAA, but I know they'll make a lot of money, so if they are in trouble, they'll have a safe berth.
Yes, yes.
It's what I call an exit option. Exit option is very important. I tell my students. My late wife, when she was working out at the gym, I said, "Holy moly, I'm in trouble." She's working on her exit option. We're working on everyone's exit option. We want you to be really valuable, because the more valuable you are in terms of your exit option, the more your employer will value you, believe it or not. If they think you're stuck, they regard you accordingly. So this is a great program, co-sponsorship with lots of organizations. And I'm going to turn it over to Eric right now. Also, apparently the chance for the Biden administration to get back at Iran, they're going to be playing Iran this afternoon at 2:00, which is the time of our reception. And let's see if they do better with Iran here than on across the negotiating table. Thank you.
Thank you, Sam. And thank you, Allison, wherever you are, for setting this up, and Nick. I'm Eric Fishman. I want to thank everyone for coming. As Sam said, there's another sporting event going on right now, which we didn't realize was happening when we planned this a few months ago. So we are going to stop this, I promise, right at 3:00. We'll be able to watch the second half. It's going to be right above us as we have some drinks. So thank you for coming and missing the first half. If I get updates like on my phone, I'll try to tell everyone what's going on. But we're really thankful for everyone for coming. This is an exciting area, how athletes could monetize their name, image, and likeness now. New forms of compensation. I think we all know, a decade ago, athletes were really compensated much differently than they are today. They got their salary from their sports contracts, and every once in a while they get money from, signing autographs at conventions or, shaking hands at the local truck dealership. But now with the internet, social media, esports, crypto, the metaverse, there's so many different ways that athletes can monetize their NIL. And with these ways that they can monetize their NIL, there's also risks. We're seeing a lot of those risks, and all of us up here today try to help our clients mitigate those risks. We're going to talk about some of those today. So before we get into it, I just want to all of us introduce ourselves. Like Sam said, I'm Eric Fishman. I'm the head of the sports group at Pryor Cashman. I really got into this area probably 4 or 5 years ago. I represent some athletes. I guess my most notable clients, Kevin Durant, represent other businesses and entities in the industry, brands, and it's been a fascinating time for me. And this is Andy Latak, and why don't you give a little bio of yourself?
Sure. And just to add on to what Eric said, I didn't talk with NYU about this. I'm not sure the protocol, but if a goal is scored, you can just shout it out.
Yeah.
And we don't wait for updates from Eric. He's got all these cards here.
I got no cards.
Yeah, shout it out. You think I'm kidding? I'm serious. Andy Latak, general counsel at Clutch Sports, which is a sports agency that represents a number of basketball players, football players, some properties, some broadcasters, a variety of talent. I've been in the agency business for almost 15 years at this point. I was at an agency called CAA for 12 years before that. I went to college and law school at the University of Michigan, who had a huge football win on Saturday for anyone who Watched her cares. Wow, we getting some claps for that? All right. And then I went to the firm Proskauer Rose in New York, where I did sports corporate work for a couple of years before I joined CAA. And so my job at Clutch is, assisting our clients in monetizing their brands. And that's everything from the player contracts that they execute with their teams, marketing deals that they execute with brands, which we're going to get into, in depth today. Any other name, image, and likeness for high school, college players, all of the sort of expanding opportunities to create new revenue streams for athletes. I work hand in hand with our agents, to sort of properly negotiate, draft, and paper those. And thanks everyone for coming. Looking forward to today, and then looking forward to the reception of that game zone.
Thanks. So we have Clarence Nesbitt, who I think is on the screen somewhere. I don't know. Clarence, can you hear us?
He's on a call.
Oh, he's on a call. Okay. So Clarence is okay. Well then, okay. So we have Clarence, who's Chief Legal Officer of Think 450 and the NBPA. We also have Kirk Berger, who's at the NBPA. So Kirk, why don't you give a little background on yourself?
Good afternoon, everyone. Kirk Berger. I'm counsel for the National Basketball Players Association. That's the union that represents NBA players. I've been with the NBPA for about 7.5 years. Mainly deal with collective bargaining, enforcement of our agreement. We're actually in the middle of those negotiations as we speak, so I may have to defer some questions or say, don't get me fired. So please don't get me fired. At the PA, I mainly focus on the salary cap, player contracts, sort of what we call the system, but also focus on all other areas of the collective bargaining agreement, benefits, anti-drug conduct, player conduct, which will become relevant when we discuss some of the subtopics today. I went straight from law school to the PA. I graduated Cardozo, so your neighbors, in 2015, and I am a graduate of the NYU Sports Management School from 2012.
And we also have Jason Chung here, who is actually faculty at NYU, focusing on esports.
Absolutely. So thanks for the intro. And my name is Jason Chung. I actually work in the same building that Kirk was at, and also right next door is Cardozo Law. So very familiar with the geography at the very least. So on the education side, I'm the director of esports and gaming at NYU's Tisch Institute for Global Sport, really leading our sort of curricular development there. I built years ago, before I returned to NYU, I built the first business of esports course over there as well. So really focusing on esports and gaming from business angle and really how to monetize the space, because it's not always as straightforward as it seems. And on the attorney side, I graduated from McGill Law. I practiced in Hong Kong for a little bit, and now I'm the head of esports at a firm by the name of Zuber Lawler, which actually is headquartered at LA, but has a significant New York presence and does a lot of general transactional work as well as IP work and things like that. So, yeah.
Great. Do we have Clarence yet, or not yet? Okay.
I'll tell him to text me.
Yeah, that's okay. All right, so let's start it off. So I think the place I want to start off is something that's been highly relevant in the news right now, which is crypto and crypto endorsements. And we've all seen, if you turned on the Super Bowl last year, you see 1 million advertisements from crypto companies, and they're usually being endorsed by athletes. And it was such a great marriage. Crypto companies were throwing money at athletes. Athletes were taking their money and really endorsing the products. And now things have changed. You see the fallout from the FTX bankruptcy. And a lot of athletes are now embroiled in these issues of being sued by investors in these companies. It's not just, the athletes are now having to deal with some of these issues. So I guess, Andy, first of all, I know you deal with a lot of high profile athletes who no doubt have had some deals with crypto companies. What are you seeing now, and how can you really protect your clients?
Yeah, well, I think protecting our clients comes on the front end of this exchange. We're all lawyers, and by nature, I'm pretty risk averse. So, anytime there's an opportunity where everyone's getting rich and everyone's getting rich quickly, and the numbers on the offers seem too good to be true, or seem to have an extra zero on them than what we'd otherwise expect, I'm naturally wary. I think you've seen obviously firsthand, some of the risk with some of the decentralized finance and crypto and some of these riskier plays, for lack of a better term. I mean, it gets likened all the time to the Wild West. A lot of people made money in the Wild West, and some people got beat up outside the saloon and got their horse stolen. I mean, there were clients that had, not clients, I shouldn't say clients, there were athletes that have had, as Eric says, like very public sort of fallouts from dealing with crypto. And so, and you know, and there was the NFTs, NBA Top Shot, all of that. I mean, you can pick any sort of example. So I think we were, you know, we were at Clutch fairly measured in terms of rushing into this stuff. I would liken it a little bit to the NIL space. I think you can draw an analogy where it's like, okay, all of a sudden this thing exists and there's a lot of money and nobody fully understands the rules. And it's a little bit difficult to do sort of the proper diligence that you need to do if you're moving as quickly as that, you know, as you need to. And so, you know, you can rush right in and there are probably a few bucks to be made and everyone's figuring it out as they go, or you can proceed a little more, you know, a little more judiciously and try to figure things out. And so, you know, I'm not saying necessarily we did one or the other. I'd like to think we sort of pumped the brakes more than we rushed in, but yeah, you're seeing, I mean, we were talking about before, you don't see a lot of NBA naming rights deals have to get unwound a year in, like FTX Arena in Miami. Obviously, you've got crypto.com arena in LA. That'll be interesting to see. So yeah, kind of a sort of a new frontier of things to worry about if you're in-house counsel, you know.
You know, there's something you said that was interesting, which is diligence. And a lot of times athletes don't necessarily do diligence before they endorse a product or invest in a product. And a lot of the athletes not only endorse these crypto companies, but also we're investors and owners. And I see we have Clarence now. How you doing, Clarence?
Good afternoon, Eric. Good afternoon, everyone.
So Clarence, we're talking about crypto, and I know that you talked to probably some NBA players about the risks of endorsing crypto and maybe some, the risks of endorsing products in other industries such as cannabis. But Clarence, why don't you just give everyone a little bit of background and then maybe you could talk about this topic a little bit.
Well, I think there are two forms of liability that crypto endorsements present. One of which athletes are familiar with, and the other, I think, is uncharted waters. So the one that they're familiar with are the risks associated with the normal disclosures that the FTC requires, making sure that it's clear in the marketing communications, the athlete's relationship with the company. And that's the easy one. The more complicated one is the potential aiding and abetting and securities liability claims, both on a state level, and then maybe SEC enforcement actions that are emanating from the relationship. And this is not something the athletes have much familiarity with. And as we all know, securities law is a somewhat esoteric practice of law in the mind of, at least in the standard sports and entertainment attorneys practice. So this is uncharted waters really for counsel on the other side of the table as well. And as you guys rightly said, people have jumped in with both feet because of the eye-popping cash amounts that these companies have been willing to pay to get top-tier endorsers, and now we're dealing with the wreckage of that in the form of the litigation that has ensnared Tom Brady and Gisele Bündchen and Steph Curry and some others who have been prominent players in the space.
One thing that I would add too, we always counsel our athletes, you really only get one chance to establish your credibility as a brand ambassador. And so, there you can think of plenty of cautionary tales where, an athlete is endorsing something, and that really threw me off. I got so excited. It's my girl. No, it's Motown. I don't know why that threw me off so much.
Why don't I kick it to Jason?
All I was just gonna say is you only have one chance to sort of establish your credibility as an ambassador. And if you make a mistake, and a high profile mistake, a lot of times that will stay with you for the entirety of your career. And you build up this equity in terms of the audience believing you and trusting you that sort of what you're selling them is not a scam or is legitimate. And so it's really tough to kind of put that genie back in the bottle.
And we'll talk about that more when we talk about social media, because there's so many ways to get in trouble with social media. But Jason, is crypto endorsements big in the esports industry?
Huge in the esports industry, unfortunately. When we talk about traditional sports has the the benefit of media rights, right? So that's how basically people make money in pro sports, at least in North America. With esports, you generally don't have that, or even if you do, it's really fractional. So really, when you're looking at teams or leagues, they're trying to make money, and they try to make money through sponsorships, right? And so obviously, what you're open to is probably a lot larger than what the NBA community might be open to, what the NHL community, NFL, all that kind of stuff. So, some teams have jumped in whole hog and actually accepted huge amounts of sponsorship. So TSM, for instance, which is a big esports organization, accepted, I believe, like a $200 million plus sponsorship over 10 years from FTX, right? And they actually renamed their organization to TSM FTX. What do you do in that situation, right?
So what are they doing?
So they've said that they're concerned, that they're looking at it, but they haven't changed their name on Twitter. So, we'll have to see. Really, at the end of the day, for them, the worst case scenario has come to pass in the sense that, not only has the sponsor run into trouble, but now they're, some of the money has been paid out, and obviously some contracts still remain. But then the question becomes, how do you actually pay out the rest of that? Are you going to get anything? Is it worthwhile to keep that sponsorship because it's a big chunk of your revenue source? All those questions, remain to be seen, and the unwinding will be fascinating.
So a related topic, Kirk, is a lot of athletes are now taking their compensation in crypto. So it's not just endorsing the crypto companies, but it's also being paid in crypto. And it's not just endorsement money, but a lot of athletes are converting their actual player salary into crypto.
Sure.
And there are a ton of issues, and some of the athletes like Odell Beckham and Saquon Barkley look like geniuses, a year and a half ago, and now have lost a significant amount of money. So, someone who, is on the union side, what do you tell the players here?
Sure. Well, fortunately, and it's kind of paternalistic on the NBA and in our collective bargaining agreement, you actually cannot take your currency in anything but USD. So for better or worse, we've sort of saved ourselves there. And I think, the biggest thing is really with athletes and on the education side of any investment, whether it's crypto or it's NFT or it's marijuana or it's sports betting. What makes it so difficult is that, and it's really a testament to athletes generally, is that they are so far ahead in the business world that they're getting these opportunities. They are the litmus test, unfortunately, for better or for worse, because there's no one coming before them where the average consumer or the average investor is saying, oh, well, I already see how this is panning out. So that's what's tough. From the PA perspective, we try to, we educate as much as we can. We have union team meetings and various all sorts of educational meetings with players, whether it's on finance or other subtopics, investment, and really just trying to get out to the forefront, providing background investigations. When they ask, we always provide financial background checks for players and things of that nature. But yeah, it is a very tough, it's a tough task when athletes are really involved in a lot of these from the ground up and advising them on new law,
Right. I get it. I understand why it's a sexy thing for the athletes to do, is to convert their salaries into crypto, to try to have diversify their income streams, hedge against inflation. I think some of them don't realize that it's not just simple as like, hey, pay me, Bitcoin in exchange for my services. There are things you need to put into an agreement, Andy. I'm sure you deal with those all the time. The athletes have to have a wallet. You have to really understand how the conversion rates are going to happen. So, what legal issues do you see in these contracts when athletes want to get paid in crypto?
Yeah, well, thankfully, like Kirk said, at least on the NBA side, a few things. So the CBA requires you to be paid only in cash, and then another CBA provision that came to light, and Kirk and Clarence can correct me if I'm wrong, but when Spencer Dinwiddie wanted to tokenize his contract, there's a provision that says that you can't assign any portion of your earnings to a third party. And now,
That's right, Andy.
Yeah, I feel like there are some instances where kind of the rules, for lack of a better term, haven't necessarily caught up with what they're policing at the time. Like, I would imagine that provision was put in the CBA to, I don't know, but to stop players from granting part of their contract to a loan shark when they owe money, and then you have to worry about fixing it, that sort of thing. I don't know that it was put in place to police tokenization of contracts, but maybe it's a good thing that it does until we get our arms around this thing and sort of figure it out. The owners write their checks in cash, and then the players are free to do what they want with it. Like, I believe the Odell Beckham and Saquon example and Trevor Lawrence, they all converted their contracts. They took the money from their teams in cold hard cash, and then they converted it. And so you can do what you want with your money after that. But yeah, I mean, I think that, and I would do the same thing if I were, young and wealthy and sort of like interested in what's next, whether it's wine or crypto or, or cars a while ago or
Right.
tech startups or, you have people with disposable income that are sort of, there's talk in the locker room about, well, I'm investing in this. How are you not in crypto? How have you, how do you not have your own line of wine when wine is really popular, that sort of thing. And so, there's always just a little bit of a temptation to try to ride the next wave because at the end of the day, most of these athletes are not going to lose their shirt. They've got enough money in the bank. And so you take a little bit of a hit from a brand equity standpoint, but, I'd like to think that their financial advisors and their representatives are not letting them invest more than, what's sort of a little bit of a fun amount to that athlete, where if this thing goes belly up, like a lot of these things do, you're still keep the lights on.
Let's hope. So you talked about tokenization, Spencer Dinwiddie, who tried to, securitize his contract. You know about this because I know you deal with Socios and, I think some of the other countries particularly in Europe are ahead of us. And they have, different kinds of securities laws. But do you see this as the future where, athletes and I don't know, esports, gamers are going to eventually, securitize their contracts and, sell parts of them and try to make money that way. Do you see that as a future?
I don't know if I see that as a future. I see some people doing it, some of the more risk takers among them trying to do that. But by and large, I think still there's a reason why contracts and the legal profession sort of exists the way it does, right? Just getting to your point, Andy, about why, contracts look the way and you can't assign rights away. It's probably because, they've tried to do this in non-technological terms before too, right? Giving it to a third party that controls, and they did that in soccer for a bit before they started clamping down on that. So I do think that these kinds of new forms will be explored. I do think that traditional sports entities will probably frown on them until it's like really settled. And I think that's the big distinction here, right? There's a distinction between investing your money in a technological platform or a technological offering like Bitcoin, and then putting your money all in an exchange.
Right.
And I don't foresee that happening, right? I see the NBPA actually having some things to say about where you park your money and doing some education on that. But, at the same time, is there going to be innovation? Yes. Is it going to look the way that, futurists think? I don't think so. I think there's too many people like us on this side of the table that are going to prevent them from doing that.
And to bring it on home, I think the assignment clause actually came in, and this just shows you how far athletes have come, because athletes were assigning the contracts to their personal LLCs as tax shelters. I think it came out, there's some tax law cases with the NHL. It just shows you how far the athlete has come from, oh my God, an LLC to, now where we are with crypto and all
That's
that.
right. That's right. By the way, does anyone have a score on the 0-0? Okay.
Keep them coming.
Yeah, exactly.
Can I chime in with one point?
Sure.
I think the issues and the various areas of law that this conversation has touched on should really impress upon the audience the importance of getting as broad of an education as possible. Because, sort of before you thought, okay, I need to know litigation, I need to know contract law, maybe some tax law, and then, sort of sports specific issues. But as you see, new industries and new categories create new areas of knowledge that counsel representing teams, athletes, or unions need to be facile with.
That's exactly right. And it's, goes to what I said before, is doing your diligence, understanding what you're investing in. Don't just, counseling athletes, don't just invest in something because their teammates investing in it or because their buddies telling them it's a good opportunity.
I just wanted to ask a question about, you mentioned something that's pretty obvious to most of the audience, that is very important for a professional athlete, any athlete, to have integrity and be aligned with a brand that has integrity. So I'm curious about your thoughts of Subway. Subway seems to have spent a lot of money signing up A+ list athletes to endorse them. Yet I understand that they had this huge scandal that they were using non-natural sort of foods and marketing them as, the authentic real beef or chicken, and it was got filler in it. So could you speak to that? Maybe I'm wrong. I don't know. That's what I recall happening.
Well, I don't know about Subway. And you're right, they do have a lot of high profile athletes, but I think it goes to the point I was just making where you have to make sure your athlete completely understands who they're endorsing, who they're investing in. and that their interests are aligned. If your client, you know, is a vegan, maybe they don't want to endorse Subway, or they have some specific views on certain things. But I think even more than that, you know, you need to make sure that you're investing or you're endorsing, you know, an ethical company, a company that's going to be viable, a company that's going to do the right thing. Because the last thing you want is to be in the press, because the company that you invested in or endorsed did something wrong, violated something, has some SEC violation. You know, it's like what Andy said, you have one shot at this, you're going to get a lot of money for it. But what you don't want is to have to spend a lot of money hiring a lawyer, or dealing with, you know, the bad press.
Yeah, and there's some,
Have a morality clause that the athlete can get out of it.
You could have a morality clause. It's probably a reciprocal morality clause.
Yeah, no, absolutely.
Yeah.
I would say that, you know, if in rare cases where an athlete has an inordinate amount of leverage, you might have a morals clause in favor of the brand. You know, I think in most cases,
pretty
the
rare.
pendulum has swung where you see a lot more examples of athletes getting into trouble and the brands needing the protection. But certainly in a case like that, you would like to have that protection. Yeah.
yeah, and this is also the soapbox moment to say that, you know, ESG sort of concerns aren't just the buzzword or shouldn't be just a buzzword. At the end of the day, they can help protect lots of stakeholders. So, you know, having that sort of emphasis on looking at the governance and all the different impact factors is really, really critical. And in fact, you know, for crypto, if that had existed in a more aggressive way, maybe a lot of people wouldn't be losing their shirt right now.
That's
I
right.
would amplify the point I think Andy made. For an athlete to get a morals clause in his or her favor against the company is almost never happens. I came from Nike and representing the company on endorsement deals, and that was just something that would really was almost a non-starter in terms of negotiation topics.
Right. I think that's right with respect to Nike. Maybe with some of these startups, you know, you might be able to, you know, to have a morals clause going the other way, but it's typically, you know, the athlete has the morality clause, and it's usually pretty broad. And as you know, people up here who try to protect the athletes, you want to try to narrow the ability of the company to get out of a contract based on that morality clause. But again, it's pretty rare to have it the other way. And sure.
So given the various ways that inventive ways that people are going to come up with to monetize the athlete's ability to earn athlete's brand, athlete's name, is the trend now in sports management to have the sports agent, sports representative be part of a law firm so that you have access to these various subject matters without having to go and form a relationship, without having to, you know, figure out, even though we have attorney-client relationships, you know, keeping it within your own firm is sort of better than going outside and dealing with strangers. So is that the trend in your industry now?
Not really, no. I think for the most part, you have someone like me who's a sports lawyer, represents athletes and companies. And then you have someone like Andy, who is on the agent side. You're not an agent, but who works for at an agency, and who does everything else for the athlete. A lot of legal work, but also, you know, puts them in touch with companies to get endorsement deals and marketing, and then represents them on their player contracts. You know, I as outside counsel wouldn't do that. Yeah, I wouldn't be negotiating against, for example, the Nets on Kevin Durant's next contract. So it is usually still separate, those two areas.
And part of what we provide as an agency is in-house functions like that. You know, we have finance. We're going to invoice your partners for you and make sure you're paid. We have in-house legal. You don't need your own lawyer to work on the majority of your day-to-day stuff.
That's a great thing to have.
But then, yes, but you know, you also have to know when you need help. If we have a complex equity deal for one of our clients, I will absolutely get counsel from someone who understands that better than me. You know, I'll work on a shoe endorsement deal and I'll work on a player contract and the stuff that's in my wheelhouse. But if it's something that's outside of my expertise, I'm not an IP lawyer. If there's a heavy IP component, you know, there are people then that I call to help with that.
You know, I could actually give you a good example now, which goes to our next topic, which is NFTs. And, you know, a lot of times the agent will find an exchange or, find, a company to partner with an athlete to do an NFT. And then I would negotiate the actual smart contract. And so, NFTs have been a huge area for athletes over the past, I would say, 2 years. Less so now because the market has really taken a nosedive. But I get it. I understand why NFTs are so popular for athletes, because it's a way for them to go directly to their fans. So they don't have to, sit in a convention center and sign, baseball bats or basketballs. They can go directly to the consumers through the exchange. And it's a way to be creative and monetize your name, image, and likeness, and really have control over your IP. But there are a ton of issues. And, I've dealt with Clarence on this a few times. A lot of athletes don't realize that, they need to clear, the IP of whatever asset they're putting in that NFT. Did we lose Clarence? Right when I was about to call on him. But, for example, if an NBA player wants to put out an NFT and has another NBA player in it, they have to talk to Andy and Clarence. If they want, if they have if they have their jersey in the NFT, then they have to talk to the NBA. So, I guess, Kurt, this is a great area for you. I think this is, a lot of athletes don't realize that it's not as simple as just putting out, some piece of art. That there are a lot of other factors that are involved in that.
Yeah, it's funny. Clarence is back. I could tell this story. We actually had a player reach out to us who wanted to make an NFT of his championship ring. And we were like, he had gotten the ball rolling. He was already talking with designers, and he was like, okay, well, then they came to us to make sure it was kosher. And we were like, no. You don't, in fact, own the underlying IP for the ring. There's a ring designer, whoever it may be, who owns those rights. So it's definitely, and we had the player say, but what are you talking about? I have the ring. I have the ring right here. What do you mean I don't own the IP for it? So it's definitely added another layer, and we've seen sort of the legal cases flying out left and right with respect to copyright and NFTs. And again, it's just about educating the athletes. Unfortunately, this athlete wasn't able to secure it because it had not only the IP but the league marks. And as Eric and Clarence can attest to, the league holds on to those marks closer than anything else in the world. So, but it is an interesting area.
I mean, I had an athlete come to me and he said there was this cool photo of me that someone took, and I want to make it into an NFT. And I said, do you have the copyright? Do you own the rights to the picture? He says, I have no idea what you're talking about. So you just need to really counsel your clients that that ownership of IP is key. I know Clarence can weigh in on this.
I think Kirk actually stole my thunder with that story. Thank you.
So Andy, let's dive a little deeper into this, because you have smart contracts with NFTs, and it's there are, I don't know if everyone knows this, but you put out an NFT and you get a royalty for whoever buys it, and then if whoever buys it then sells it to someone else, you can get a secondary royalty. So it's a great way for athletes to continue getting a revenue stream. But there are things you have to put in the smart contract to protect the athlete, right? Yeah.
US forward.
Okay,
All
good.
right.
Yeah.
I don't know how I follow that up.
Yeah,
Yeah. So, I mean, the smart contract is a great mechanism to sort of discuss this, because, 10, 15 years ago, pick a clutch basketball client, Trae Young, LeBron James, Anthony Davis, when NBA players a certain level have shoe deals, they'll typically get royalties on those shoes. So you sell a pair of LeBron James sneakers and there's a certain percentage. You sell a pair of Kevin Durant sneakers, there's that sort of thing. And the royalty is, the royalty is executed when the sale is made, and there's one sale and somebody takes home their shoes and they play basketball on them, or they keep them in the closet or whatever. With NFTs, there's perpetual sales down the line. And so, what I have to work on is, educating myself and brands that sort of like the idea of NFTs, but need to understand, like, okay, with a memorabilia company or with an apparel company, when we're doing this, the royalty language and the royalty component is totally changing. We're talking about an entirely different ballgame where, it's essentially in perpetuity. And whether your accounting department is set up to manage that or not, like that may freak out your lawyers to see something in perpetuity. But the fact of the matter is that the royalties, really are, at least for a really long period of time. And so, royalties are an integral component of how athletes get compensated, and the royalties on the NFTs just completely alter the calculus.
It's also a great way for you to control your own IP. Because you continue to control that in the smart contract. You don't lose your IP. So, Jason, are NFTs big in the esports industry?
I think the answer that I keep giving is that they're trying to be, so I think commercializing obviously sort of name, image and likeness is huge in esports. The problem is that unlike, there's even more hurdles than in traditional sports, right? So if LeBron James, for instance, decides to dunk on a hoop in his backyard, that's not a problem, right? I mean, he can probably put that in an NFT. But if you're talking about an esports athlete, the entire game is actually an IP, right? So how are you going to actually demonstrate that? What are you actually going to clip? Are you going to clip their reaction? Are you going to clip the actual game that's going on? All of that is under debate, right? And then, so that means that game publishers also have a huge seat at the table because they actually can enforce the IP or not. In fact, the gray area of whether Twitch streamers are allowed to Twitch, are allowed to sort of stream the games is still a subject that's under some debate, right? I know some NBA players like to stream like 2K and stuff like that, right? If there was money to be made at a significant clip, I think 2K would probably do something about that. But right now they're taking it as free advertising. Is that going to be the same for esports in perpetuity? I don't know, and definitely the minute that some element of their art or image gets clipped and gets commercialized, then you're going to definitely see the publisher step in, and they already have, to be clear.
So it'd be interesting to see what happens with this over the next, I would say, year. If the market comes back and whether more athletes get involved. There were a lot of different actors in the NFT space, I would say 6 months ago. A lot of my projects from my clients have been on pause or stopped. They're slowly coming back now. And I think everyone is sort of trying to see what the market is going to be like over the next 6 months and what the different issues are going to that may arise. So I think it'll be interesting to see. All right, so the next topic, and these are all sort of related
If I
to
can
each other.
interject, the score is 1-0, by the way, USA.
Yeah, we got it. We got it. It's probably almost halftime, right? 43 minutes in. Okay.
Clarence totally has the game in front of us.
I know, he's-
That's why he's doing this virtually.
I
That's
know.
smart, actually. I'm going to do this virtually for the rest.
So I guess we'll go to the next area, which is just the general area, just licensing your name, image, and likeness. And we've seen, in the college space, it's obviously brand new, and to use a phrase that Andy uses, the Wild West. But let's first talk about the professional space, because there are all these different types of ways for athletes to license and monetize their name, image, and likeness. And the key is really enforcing their IP, making sure that they're applying for trademarks, making sure that they're going out and ensuring that no one's violating their IP. I think in the NBA space, Giannis has done a phenomenal job of going out and really protecting his marks. The Greek Freak, I think he filed dozens of lawsuits to protect his IP. You see other issues like Luka Doncic is in a lawsuit with his mom because he signed a consent order when he was I think 17 years old, giving her the right to apply for a mark, and now he wants it back, and he's in a lawsuit with her. So Clarence, you probably talk to the NBA rookies when you speak to them and they're coming in and you tell them about how important it is, and in your role at Think 450, you deal with these licensing issues all the time.
Yes, and one particular one that the audience might find interesting would be with respect to tattoos on their body. There have been so many lawsuits as of late involving tattoo artists and video game companies and other companies that make usage of the art on a player's body. So one of the first things when given an opportunity to address players about this is to tell them to make sure they get an assignment of the artwork from the tattoo artist who owns it. And we've had these issues, big and small. I don't know if there are any fans of the movie The Hangover, but I think in the second one of the characters had the same artwork that Mike Tyson had on his face, and the tattoo artist sought an injunction. I don't believe he was successful in getting it, but I think he did extract money from the studio based on the reproduction of the art. So all of these issues with respect to licensing, with respect to control of a player's name and the registration of names and trademarks related thereto are critical issues for the athletes to secure revenue streams and actually to even provide exclusivity to some of their partners, because certain of those marks they might want to pass on to those partners in exchange for increased value.
Sure, and Andy, it's of utmost importance to protect, your client's IP, and I'm sure you monitor their IP and send takedown notices. But how do you advise your clients on this issue?
Yeah, we get the question all the time, particularly from our young clients. We're talking about, Clarence and Kirk advising the rookies as they come into the league. Everybody wants a brand and a line of clothing and a trademark and a logo. And so, when that request comes, my conversation with them is, okay, well, here's what we need to understand. First of all, it's going to be relatively expensive because you need to file in a certain number of classes. We need to determine what you're going to do, what your plans are for this. But then you need to police it, like we're talking about. And, Giannis is an interesting example. Like you have to sort of respect what he did, because I think he got something like an $11,000 judgment that I don't even know that he's going to collect. It was a default judgment. He's doing it basically to deter people from not. Yeah,
That's right.
it's from one of those
He
little
actually got
sites.
zero in damages.
Yes.
But
And it's from the sites that pop up that we see all the time. It's like playing whack-a-mole, and you can't even really reach them. You can send a cease and desist through some form on the website. You don't know if it ever gets to them. So back to the trademark conversation, but you have to be prepared to put out apparel or put out your line of jewelry or put out your line of sporting goods or whatever it is. And you've got to show use before your trademarks are going to get registered. And so it's, sometimes athletes will think, well, okay, I had a great line in an interview draft night. I want to trademark that. And it's like, that's just the beginning. And that might not necessarily be the best move. But, once you do reach a level where you're having to protect that, and you're having potentially your own lines of merchandise, then yeah, I mean, it's a full scale effort. You've got to police it. There's significant expense. If you want to do something internationally, that's a whole separate can of worms. And so, yeah, I think it's an educational process that we go through with our clients to make sure that they really want to do this and everything that it entails.
I for one of my clients about 6 months ago wanted to put out an NFT on an exchange, and we went on the exchange to see if this athlete's image was anywhere else. Was being sold anywhere else. And I think there were about 500 different NFTs of his image. And, luckily we had a relationship with the exchange, so we got a lot of them taken down, but it's not an easy thing to do. I also think, there are other companies now, particularly in like the gaming industry, that have been using athletes' images. And we've been having conversations with them that they're, not necessarily allowed to do that. So, athletes right now are able to monetize their NIL as long as they protect their IP. And if they protect their IP, then they can go out and really make a lot of money if they are at that level. Is it the same in the esports industry?
Not as much. I mean, to be quite honest, just simply because, if you ask, you can ask a couple of my students there, who are 3 esports athletes, I think they'd struggle. Not because they don't care about the industry, just simply because they're not as renowned. And, esports athletes have a shelf life of 2 to 4 years. So at the end of the day, you don't have that long career and the notoriety to build up sort of NIL.
How about the teams?
The teams do, on the other hand, right? So the thing is, they've been trying everything to insert themselves in different sort of contexts. Merchandising is huge, obviously, just on the physical goods side. But then, yeah, they're building out their virtual storefronts and everything like that. In fact, if you look at FaZe Clan, which is a big esports org that actually formed SPAC and went public. If you look at their revenue projections, even under their own financial sort of forward-looking statements, only 3% of their revenue approximately comes from esports and esports related things. Everything else comes from digital merchandising and other different channels and streaming and lifestyle things. So at the end of the day, it's viewed as critical, I think, to the lifeblood of the industry going forward.
Andy, I'm sure you see contracts all the time where your clients are endorsing products or getting, money for, allowing a company to use their name, image and likeness. Sure. There are obviously some key terms that you put into agreements to protect them. You want to keep it as narrow as possible. You want to potentially have approval rights given to your client whenever the company uses their NIL. Is there anything else that you do to make sure that you protect your client as much as possible?
Yeah, I mean, approval is a huge one. We at Clutch, we want to see anything that goes out with our client's image on it, whether it's just some TikTok that's going to disappear or a billboard in Times Square or whatever. The agency approves everything. That's not just us. That's standard in the business. Category exclusivity is a huge one. If you're doing a deal with a beverage company and it's a water company, is the category narrow enough that your client can then accept a got milk deal if they want to come, or a coffee deal, or with Starbucks or something like that? That's the sort of thing that's really easy to overlook on the front end. But then one of our marketing agents will come to me and say, hey, can client X do a deal with brand Y? It's a better feeling to pull out the contract and be like, yeah, the category was narrow enough that, we have this whole other opportunity to exploit that, we might not have had if we agreed to their initial definition of category exclusivity. And then, sort of post-term language, right of first refusal, right of first negotiation. I mean, generally at the end of the term, it can cut one of two ways. If our client has played really well during the term of the contract, let's say it's a shoe deal, we would like to be able to take that client to market and maximize his or her value. But, a lot of times, as Clarence can attest from his time at Nike and the other brands, they want first and last bite at the apple. They were the first ones to commit to the athlete. They want to make sure that they can retain the athlete if they want to. So we spend a lot of time arguing about that. And, that is another one where, most brands feel very strongly about that and generally wind up getting their way in some form.
How about the morals clause?
We argue about the morals clause. As I said earlier, I think that pendulum's kind of swung. There have been enough instances of athlete misconduct and brands getting burned where, any brand is going to insist on some version of it. And then you're arguing about the language and how you can narrow it. But generally, what are sort of the famous athlete screw ups? If you've got a DUI or you're otherwise
You want to
getting
try to make it as
arrested, or
objective as possible, right? It's subjective.
you do, but it's sort of a no when you see it. Like if something happens, you sort of know whether that's going to trigger more like, ooh, that's really bad, or oh, that's not so bad. There's not a whole lot of generally I either know what position the brand's going to take. Not that I'm in this position a lot with athletes that trigger this, but it's sort of like, when you see it, I think, regardless of what the language says.
So, we just brought up a ton of issues related to licensing and IP and endorsement deals. And now college athletes have to deal with all these issues after the Alston decision. And it really has been the Wild West. There's no uniform regulation which regulates how these college athletes could get compensated and what they're able to do. Each state has different rules. There are compliance officers at schools. There are collectives now. It's a really difficult area to navigate, but it's an exciting area. I mean, it's great for college athletes. They're able to now make money. I just remember back in the day going to stadiums and seeing uniforms. People wearing these college kids' uniforms, but they didn't get paid for it. So the colleges and the NCAA were making a ton of money, but the athletes weren't making anything. So it's a great thing. We need more regulation. So, I guess, Andy, I'll bring it back to you because I know you guys rep some high school athletes and college athletes. What are you seeing?
Yeah, I think it's another one of those areas where the guidance that's on the books hasn't necessarily caught up to the reality of the moment. And so a good example of that is, you look at the state athlete agent laws that have been on the books for a while, not NIL, but just what regulates, you have to be certified to be an agent in a certain state. A lot of times those laws will have language that's completely contradictory to NIL. It'll say, if you have to have language in your contract that says if you sign with an agent, you're going to lose your eligibility. Well, that's obviously not the case because in NIL, you can sign with an agent and not lose your eligibility as long as everybody complies with all the rules. So I feel like it's a little bit of it's just a little bit of a fluid process where a lot of these scenarios we encounter at Clutch, it's kind of like a law school exam question. You have a player who went to high school in Pennsylvania and is going to play basketball at UCLA, but in the off season is doing his training in Oregon. That sort of thing. Which law applies when the high school, when the career sounds on this athlete's high school buzzer? When the buzzer sounds on this athlete's high school career, what laws is he subject to? And When I don't know the answer, I have, when I don't know the answer, I have, smart outside counsel who happen to be in the audience that they can give me the answer, and I think they're gonna throw a tomato at me if I say anything wrong, so. But it's not, there's not always, it's frustrating because there's not always really clear guidance, and it's enough to sort of make your head spin.
Yeah.
But I think at the end of the day, and sorry, this is the last thing I'll say, and then I'll stop talking. It's important to note that our interests are aligned with the schools here. So I have now a Rolodex full of compliance officers that I didn't have before. And so we'll sign, Juju Watkins is a client. She's the #1 high school player in the country. She committed to USC. I already have a dialogue going with the USC compliance officer because we've had other NIL clients that go to USC. And so it's important that those people know that we're going to be above board. We're going to be transparent. I want to solve this problem with you. Both of us want the player to be eligible. If I have a question, I want to be able to call you, and I want you to understand that we're doing things the right way, and we're going to keep you all in the loop, because I think the compliance officers, like anyone else in the NIL space, are just trying to keep their heads above water and trying to navigate this new space. And so I view us as allies in that sense, as opposed to there are other scenarios where maybe the agency and the school don't necessarily lock arms like we are in this case.
Well, the Bronny James of the world are lucky to have you. But the offensive lineman who's going to, Texas A&M may not be as lucky, and they may be part of a collective. And they may hear that this collective has $20 million. So they think they're automatically going to get a piece of that, but they need to understand that they actually have to do work to get some of that money. So Kirk, I know me and you have talked about this before. You have athletes that come to the NBA and they're dealing with this. What are you seeing out there?
So as Andy said, I wish all the agents were as altruistic as Andy and Clutch, because so the issue that we've seen on the college level, and again, we have at the MVP have a great relationship with the NCAA, but we certify and regulate the agents, work as an arm and extension of the union. And we have rules on the books that we don't want agents doing anything that is obviously going to be violative of the NCAA rules or jeopardizing anyone's eligibility. And what's kept me up at night a couple, I guess this was last year, where you had certain agents who were not working with the schools, but actually leveraging schools against each other, really doing exactly what the pay for play is, which you're prohibited from doing. And we really read a bunch of agents the Riot Act, like, listen, like, this is all brand new. If you're stepping in this gray, be prepared that if, it cuts the wrong way, that you are going to be in trouble, because if you jeopardize that athlete's college eligibility, you are going to be on the hook with us. So that's really, that's the biggest piece that's really kept us, myself at least, up at night in terms of the agent regulation piece. But thankfully, most agencies and agents already have relationships with those colleges or those college programs. So it's not sort of this, I don't say renegade, but the agents who are out there trying to leverage one school against itself. So thankfully, it's not as big of an issue, but that's really been the number one issue that I've seen. I'm sure Clarence has other stuff from the NIL perspective from Think 450, which is the for-profit.
I think we like it. It's an opportunity really for us to deal with players who, one, financially don't come into their pro career basically broke. Two, it gives them opportunity to build some financial savvy and some deal savvy in the process. And then three, I think it readies them for participation in the licensing program that we run as well. So they have some familiarity for group rights, the value of those group rights, and how they are different from the individual rights. And then I think lastly, it also levels the playing field internationally, because take for example Luka, who was mentioned earlier in the conversation. Luka was making money and a pro athlete playing at a top level European club, Real Madrid, from the time he was a teenager. Why should an American who is just as good as he is not have the opportunity to monetize his intellectual property, his name and likeness rights in a similar fashion? So, I think we're a fan, and just generally being on the union side, we stand for player empowerment and maximization of player money as much as possible, and this helps to do that.
Yeah, I'll say one more thing. It's also added in an interesting wrinkle in sort of the recruiting game, because it's given just another factor where agents will, for better or worse, try to poach other people's clients and say, hey, oh, you got $1 million in college. Well, I would have gotten you $2 million in college. Or, oh, your guy didn't do enough. Or look at how I did with these other athletes. It's added another level to the recruiting game and sort of that ecosystem, which is, and obviously, relationships are cultivated while players are in high school and in college. And now it's really just added a whole nother layer. And it's very interesting. It's going to be interesting to see how, from Andy's, how the agencies adjust to it and recruiting and all that.
Yeah, you just got to start working earlier, and early on in NIL, you still have your existing staff that are charged with getting marketing deals for a full roster of pro clients that are now, also responsible for NIL activity. But yeah, I think that's, it's obviously great if you're on the talent side, and I'm all in favor of people, being able to exploit their name, image, and likeness. And I think from the agency side, it's a great opportunity to get involved with great talent early on, provided you do it the right way. And there's also potentially downside, you have a couple years longer to represent someone, and maybe it doesn't go great, and maybe then they wind up taking other meetings, things like that too. I mean, you have to be confident in what you're going to be able to do with that added runway before you bring someone on.
So it's a little after 3. We're out of time. Go ahead.
I have a question about the, I guess you know about the Penn State waiver case against Vintage Brand, where they, so basically the Penn State sued Vintage Brand for merchandise where they use the old Penn State logos. And, basically the case was that the district court judge basically said that Penn State does not really have a right to exclusively use the logo and the name, since it's merely ornamental. And it could have very serious implications on the whole college sports industry and everything related to it. So I'm just wondering if you're aware of it, whether your views and potential implications.
Well, I'm not aware of that case, but
I'm not.
so.
Yeah.
You
should be up here.
Yeah, you've stumped us, but there are, we talked about how important it is to protect your IP, but there are different ways that people can use your IP that don't infringe on your name, image, and likeness. So I guess that's what the holding was in that Penn State case. But there's the Hermes case right now against they sued an artist who put out a Birkin bag as an NFT, and it's Judge Rakoff dismissed the motion or denied the motion to dismiss that the artist filed. And it's going to be really interesting to see what happens with that case, to see if Hermes is able to prevail and be able to protect its brand against someone going out and selling Birkin bags as NFTs. There's also the Nike StockX case, which is really interesting case that I think a lot of people in the industry are going to follow. So you're right. I mean, we talk about how important it is to protect your IP, but it's not always a possibility, but you do your best to do it, especially if you're an athlete.
And it sounds like from what you described in that case that, well, even though Penn State lost, what you see and what you see on the NIL landscape is the colleges zealously protect their IP to the point where if you have an NIL athlete and he or she is doing a deal with a car dealership, you can't be in your Kentucky uniform, you can't be in your Alabama uniform unless you've also got a deal with the school, because they're aware that this person's price might be a little more if they can have the Oregon Ducks uniform in that, in that ad. So the colleges have to be okay with their marks being used in an NIL deal, or it can jeopardize the player's eligibility. So, but we will look up that case that you mentioned.
If anyone else has any questions, we're gonna stick around here, have a beer while we watch the game, or you can ask a question now.
Thank you. Thank you for this very knowledgeable panel. I want to raise the issue of women's sports. We have 5 men up here. We're in the World Cup, Men's World Cup. Can you talk about how the women's national soccer team has had such great success as a marketing engine? And how does that, I'm very curious how professionals like yourselves view the value of the women's national team versus the men's national team with the different levels of success, and anything you'd like to say about that?
I could say it's been incredible to watch them. It's actually an incredible time for women's sports. I represent a bunch of different women athletes, but also companies in the industry that focus on women's sports. One of them is called Just Women's Sports. and it's a content company focused only on women's sports. And I could tell you that a lot of the influencers out there, particularly women's college athletes, are making a lot more money than their male counterparts. And I think a lot of that has to do with what the women's soccer team, did to advocate for fair pay, equal pay. And it's been a real testament to them to see how that's affecting all the other women who are in sports right now.
They kept winning.
Well, they're very successful.
That's why.
Yes.
I also just want to note that we did invite some women for the panel.
We did, yes.
Just quickly, Clutch launched our first women's sports division in January, I believe, and we represent, as I mentioned, the #1 high school player in the world, and 3 members of the Las Vegas Aces who won the WNBA title. Asia Wilson, who was, I believe, league MVP, Chelsea Gray, who was finals MVP. Our CEO, Rich Paul, is big believers that he wants to represent people who have great stories and have great character, and regardless of what sport you play and what gender you are, that's sort of his ethos. And so I've seen that firsthand, and it's been exciting to sort of see the opportunities for them and the marketing money and the interest that they draw on the social media engagement and all of that. And I do think a lot of that probably flows to some degree out of the success of the women's national team, which I believe their final is still the most watched soccer event in the US. It was not a men's match. The final, 4 years ago or whatever it was, still has the highest viewership numbers.
And I'll steal a little thunder from the women's national team. I think also, and Clarence can attest this as well. At the NBPA, we also have our sister unions. We represent the WNBPA, the WNBA with WNBPA, and the G League, the men's minor league. And we were part of, Clarence and I were both part of the negotiations in 2019. And I think the WNBA players, real testament, they really took them, they wanted to be taken more seriously. They wanted to be marketed more heavily. And I think you've really seen that, and a lot of what went into that agreement was focused on sort of this mutual buy-in from both the league, the team, from the league/teams, and also the players that, give us a chance, give us the chance to market ourselves and prove to you. And I think it's really, I don't have the numbers off the top of my head, but the viewership for the W has blown up, and I think it's really a testament to really buy-in from everybody, and also you see it to the extent with political activism, or obviously BG, who's still in Russia, who I know Terry Jackson, our executive director, would be mad at me if I didn't mention that, and seeing just all the amplification of all those women's issues and issues in general. And I think it's been a lot of hard work by them as well.
I think just to add to what Kirk said, we shouldn't touch on this topic without encouraging everybody in the audience to support women's sports, because that only makes their voice louder at the table. So, buy a ticket to a game, engage with their social media content, buy a licensed product, because that's really the best way for the sport to grow, is that the business case demands it. So please continue to support the athletes as well.
I think that's a great way to end this. And again, thank you everyone for coming. We're going to stick around. Thank you.